Let's talk about the requirements of a will. A person can leave their assets to whoever they want. However, there are some formalities that a testator will have to comply with to ensure that the testator understood that their actions, that they understood their actions and that they acted voluntarily. So those things, that's the reason why we have formalities, so we can ensure those things. And most states require these 5 requirements. Testator has to have capacity, legal age, they have to be of legal age, and of sound mind. We're going to go through each one of these particularly in more detail. The testator's intent, that they weren't under any influence or undue influence. A written document must be in writing, and there's a need for the testator's signature, but not just the testator's signature. We need signatures of people who witnessed the testator sign the will. So these are the general 5 requirements that all states recognize. So let's dive into these, each one individually. So taking the first 2 requirements, capacity and intent. In most states, a testator must be at least 18 years old. Of sound mind, that means that they must be able to understand what a will is, what they own, who their relatives are, and how they would like their assets distributed. As to their intent, they're acting of their own free will with respect to the creation of the will and the distribution of property. There's no appearance of undue influence. If it can be proven that a decedent's will or distribution plan was the result of undue influence, the will is going to be declared invalid. So let's say we have an elderly testator who has already created a will and with distribution assets going to their children. And let's say those children don't really visit their elderly parent who is the testator, and the testator has a caretaker who has come and regularly helped care for the testator. And then that caregiver brings the testator to a law office and convinces testator to change some of the distribution in the will to basically give a distribution to the caretaker. That would be an example, potential example of undue influence. So capacity and intent, 2 of the elements. Must be written, there must be signatures. So let's take these 2. The will must be written. It could be typed out, it could be etched in stone, it actually could be in handwriting, and we'll talk more about that in a little bit. And it has to include the testator's signature, and it's usually at the end of the writing, along with signatures of witnesses. Generally that witness number's 2. They sign the document stating that they witnessed the testator execute his or her will, and that's like one of the primary ideas, but I mean you can get a notary that does that, right? A notary authenticates somebody's signature, but really the purpose of these witnesses are not just that, and this is the process in New York, is the witnesses, when I say the witnesses, they sign an affidavit at the end that indicates that they attest that the testator was of sound mind, legal age, and not under any influence at the time of execution. So when I've done these wills with people and I have 2 witnesses, they are generally people in my office who act as witnesses. I take the testator through a series of questions, right? I ask him or her, like, you know, who's the president, who's the governor, what day of the week it is, and then I ask specifics about the will, so that the witnesses will say, okay, yeah, this person is of sound mind, there's no influence going on here, and they completely understand what they're doing. A witness cannot be someone who tends to benefit from the will, for obvious reasons, right? They're not impartial. And I already mentioned a notary public. In New York, they will witness the signatures of the witnesses. So we do have a notary that is involved, and that is generally to attest to the witnesses' signatures. So the requirements that I just discussed, or these formalities, they must be abided by, because regardless of what the testator's intent is, the courts won't enforce a will unless each requirement of law has been fully met. So let's take Burton here, for example. Burton loved technology. He thought it would be cool to make a video of his will. So he created the will. He spent hours editing it, adding music and captions. He emailed the video to several family members. Burton was very generous. He left property and money to 15 different people, including employees and friends. 2 years after making his video will, Burton dies. And the question is Burton's will valid? And you should be saying no. Doesn't meet the requirements. He may have had the tent. He may have had capacity. We'll assume Burton is 18 years old and he had fun making his video. However, he didn't sign, didn't have witnesses signed to it. So unfortunately, this would not be a valid will, and his distribution, if he had family members, they would be the ones who would be the first bite at the apple before any of the employees and friends got anything from Burton. As I said, a testator can leave his or her property to anyone, blood relative, non-blood relative. However, if a testator wishes to disinherit an issue, remember if they have a child or a grandchild, or a spouse isn't considered issue, but a spouse is a very important player in the distribution of property, especially if it's jointly owned property or marital, what would be considered marital property. But nonetheless, if a testator wishes to disinherit an issue or a spouse, their intent to do so has to be made clear in the will. Reason being, it's to prevent accidental disinheritance. I don't know how you accidentally disinherit a child or even your spouse of 30 plus years, but nonetheless, it has to be clear. And in New York, if the intent is to disinherit, you'd have to actually say it in the will. Language like, I intend to disinherit my eldest son, Mark. If a spouse is disinherited in New York actually law prevents spouses from being disinherited. Instead, a spouse who is disinherited can go to court, will or no will, and claim their what is called an elective share, and which is either greater, it's the greater of $50,000 or 1/3 of the estate. So you can't disinherit a spouse, even if you try to. New York law prevents that from happening. A holographic will, it's a will in the testator's own handwriting, it cannot be in someone else's handwriting. You can't be the testator and say, here, write this out for me. It cannot be typed or handwritten by another person. But you can write out your will. You can write out your will, you can sign it, and you can have witnesses attest to it in New York State, as long as you have the special affidavit of your witnesses. But really where we see holographic wills is it doesn't meet those formalities. Basically, it's not witnessed. It's handwritten, and people prepare these in situations where death is imminent. Someone could be, for example, suppose Rowena is on a plane that suffers engine trouble. And for 15 minutes, the pilot's struggling to control the plane. But despite efforts, the plane crashes and it kills everyone on board. But during those 15 minutes, Rowena wrote on a sticky note, this is my last will and testament, and I leave all my assets to the National Art Gallery in Washington, D.C., and then she signs her name. And then the sticky note is found in the wreckage of the plane. Her previous will, executed in her lawyer's office, left everything, and we'll say it was left everything to her partner, Ivan. And the question is, who gets the assets? And it's going to depend on the jurisdiction, because not every state recognizes holographic wills. In a state that does, well, that's going to be the gallery, right? It would be the gallery. So like I said, not all states recognize holographic wills. New York, it's very limited. In New York, holographic wills are only recognized if they are made by a member of the armed forces. And in that case, such a will is valid for 1 year after the testator is discharged from the armed forces, or for 1 year after they regain a testamentary capacity, whichever happens first. So if they, I don't know, came out of the armed forces and they lacked capacity and then regained it, that's the very limited purpose. So you'd have to be in the armed forces. Some states have what's called a foreign will provision, and the purpose behind this is to recognize wills executed in other states. Should a person, think about a person who relocates. Let's say somebody's lived their entire life in New York, worked in New York, they made their will in New York, but now they're going to retire and move to Florida, which happens a lot, right? The will might not be valid in Florida if that's where they end up making their residence and then passing away, if Florida may not recognize it. And I actually don't think Florida is one of those states that has foreign will provisions. New York does not. So if somebody was to move to New York, they're from New Jersey, let's say, and they executed their will in New Jersey, and they die in New York, and New York is now their home state or their residence, it might not be recognized. So those things have to be considered. But let's take this holographic will. In order for a holographic will to be recognized as a valid will, it could be under foreign wills provision. If you have a state that actually recognizes a holographic will, somebody's handwritten will, apparently in the state of Michigan, right, Aretha Franklin, it was recognized. But it wouldn't be in New York. It wouldn't be recognized. We don't have a foreign wills provision. So, has to be considered where the will was made in each jurisdiction. Best advice, if you relocate and move, you probably have to update wills, and not trusts, but wills. So New York, like I said, doesn't have a foreign wills provision. Memoranda or lists, this is better discussed as an example. Fran's will provides for $100,000, which is 1/10 of her estate. It's to be divided among a group of local charities. These charities include a food bank, a homeless shelter, a refuge for victims of domestic abuse, and an animal rescue facility. These charities are listed, let's say the specific charities are listed in a written memorandum or a list that Fran gives her lawyer at the day of the will signing. So she's got this provision, says it's going to be divided, group of local charities, and generally names what those charities are, but she provides an actual list of the specifics. Does this memo or list become part of Fran's will? The answer is yes, if it is being attached at the same day the will is being executed by Fran and her witnesses. A list that it'll be documented as incorporated by reference. That language would be in the will. This list will be incorporated by reference into the will. Why? Well, think about it. Because it's why you can do it, it's in existence at the time the will is signed. But after it's signed, can you imagine what can happen, right? The whole idea of these formalities is to prevent fraud. Just attaching a list, stapling a list on the back of your will is not going to be considered. If there's an attachment to a will that's not made incorporated by reference, it's not going to be part of that will. A nuncupative will, or that's the fancy word for an oral will. A few states, including New York, accept this type of will, but only for transfers of personal property. Cannot do an oral will of real property. And if you think back through last talking about contracts, right? Statute of frauds, you can't transfer an interest in land without it being in writing. You certainly can't do it on deathbed. That's where these oral wills come into play. So only personal property transfers can be done orally. not real property. New York has some conditions in place that require a testator to be a member of the armed forces to successfully execute one of these wills. And for the will, for it to be valid, the testator has to know that they're dying, but they also have to be of sound mind. So as you can see the idea of the armed forces coming into at least having a member of, in New York, the concept of the armed forces, because they could be in a position where they know that they're dying, but they're still of sound mind. There has to be 2 witnesses present, though, and the witnesses must know that they are listening to a testator's will. Some states require that the witnesses write down what the testator's wishes were within a specific time period. So it might be within 30 days of hearing the testator's wishes. But it's rare. This is a rare will, but nonetheless, you need to know that it does exist and it's out there. And the last type of will, real quick, here's a new thing, right? We're all about electronics. We're doing electronic notary public signatures now these days. E-wills. Are electronic wills a thing? Yeah, in 4 states. They're recognized in 4 states. New York is not one of them. But it's made and signed on an electronic device, or it's made online and it's stored up in the cloud. But Florida, Arizona, Indiana, Nevada will recognize these. New York does not.